abuser lies in court, especially when you know the truth. But if you respond emotionally or interrupt, the judge might not hear your truth. In this video, I'll show you how to shut down lies with calm, powerful facts, and how to keep your composure so the judge sees you as the credible one in the room. Today, we're going to talk about how to shut down abuser lies in court without losing your cool. Number one, know the lies before court. If you know what the abuser tends to say, write down the top 3 lies they might tell. And for each one, prepare a short factual rebuttal. And also gather up matching evidence, screenshots, texts, other records that will refute those lies. If he comes into court and it's his testimony that X, Y, and Z happened, but you've got a document that shows the complete opposite happened, your document is going to triumph over his lies and his testimony. Make sure that when you're testifying that you have a calm tone to say it in. I know that it's very difficult when someone who you married and you trusted to cherish you and value you and care for you is up on the stand and they are having no issues with just spilling lie after lie about you and how hurtful that can be. But we cannot respond in a very hurtful way. We can't respond in an emotional way by allowing ourselves to raise our voices, to get overly emotional, to cry, to yell. We want to stay calm in order to combat those lies. Let me give you an example. If he's on the stand and says a lie, for example, she's making this up just to get custody, your response can be, Your Honor, I reported the abuse before any custody filing. Here's a dated copy of my police report from 6 months ago. If you anticipate the script, you can flip it with facts and with evidence. I want to talk about the top 5 lies abusers tell about their victim spouses or their victim partners in court. Number 1, she's mentally unstable or she's crazy. Abusers often weaponize mental health to discredit the victim's credibility. They may exaggerate or fabricate emotional struggles to portray the victim as irrational or unfit, especially in custody disputes. So just be prepared for that. Number 2, she's alienating the children from me. A classic lie in custody battles. Abusers may accuse the victim of parental alienation to mask their own abusive behavior and regain control over the children or co-parenting dynamic. Number 3, she was the aggressor. I'm the real victim. Abusers may falsely claim mutual abuse or assert that the victim initiated the violence, attempting to confuse the court and create a false equivalency. Number 4, she's lying to get revenge or money. This lie is often used to dismiss the abuse allegations as manipulative tactics for financial gain, spousal support, or just out of spite or retaliation, especially when the victim has left the relationship and has no financial resources or heavily relies on those financial resources. Number 5, there's no evidence, Your Honor. She's had no evidence. If it really happened, she'd have reported it. Abusers exploit delays in reporting or the lack of police involvement to argue that no abuse occurred, ignoring the well-documented patterns of fear and coercion that prevent many victims from seeking help immediately. So, number 2, how to speak when they lie. In court, the moment someone lies, don't react. We talk about these top 5 lies abusers tell because it's important for you to know what might be coming. Now, there are other things that they may say as well, but it's important that you know what these are so that you know what to expect. When they say these things in court, you are not going to be surprised. You are not going to be overwhelmed. You are not going to be overly upset because you are going to be anticipating these comments and then you are going to be prepared, which is going to help you defeat your Goliath in court. So number 2, how to speak when they lie. In court, the moment someone lies, don't react. The judge is watching body language from both of you. And in fact, it's my experience that the abuser is the one usually at co-counsel table who is overly exaggerated. They're sitting there, they're flailing their body around, they're banging their hands on the table, they're doing things with their legs, they're sighing, they're rolling their eyes. They are really causing a ruckus many times in a courtroom, and the judge is paying attention to that behavior. So we do not want to do that. We want to have a poker face when we're in court the best that we can. It is okay to be expressive and emotional when it's appropriate. It's okay to cry and get somewhat upset when the timing is appropriate. But we don't want to be sitting there rolling our eyes or staring him down or going, ugh, or making noises or screaming out, liar, or anything like that. Or that's a lie. That's a lie, judge. We want to keep our calm and our composure. So one of the things that we can do is to write down the lies. So when you hear a lie, I have with me here on my table, I usually carry several notepads with me to the courtroom. I have a big notepad and then I have a little notepad. And the big notepad I use just to write notes. So as someone's testifying or as the judge is talking, I'm writing down all of the notes so that if I need to go back and reference something again later, I can. I also recommend bringing sticky tabs and highlighters because he may say something that you write down in your notes that's really good, like it's really juicy stuff. And you can highlight that and you can remember to bring that up either on cross-examination or during your closing argument to say, can you believe, Your Honor, that he made this comment or he said these things? Then I keep a small notepad. I wouldn't recommend that you write in bold black Sharpie lies and then number it. I'm just doing that for you. But you could write down on the top of your notepad lies, right? And then as he's talking on the stand, as he's lying, write down, what is he saying? What are the lies? One, it'll help you remember them so that you can then wait for your turn to refute or counter those lies. But also, it gives you an opportunity while he's testifying, rather than having to look him directly in the face, you can look down at your notepad and you can write out the lies. So it keeps you distracted. It keeps you looking down. It keeps you looking away from the abuser. It keeps you looking away from the court. And it keeps you working and it keeps you distracted. But it helps you write those lies down so you don't forget what they are. And then wait your turn and then say calmly, Your Honor, I'd like to clarify something that was stated earlier. This statement is not accurate. May I explain why? And allow the court to give you permission. And then follow with, the correct version of events is the following, or I have supporting evidence, which you can maybe show the court. Remember, keep a neutral, calm tone. Calm truth beats loud lies every time. Document and present tangible evidence. That is so important. Courts rely on credible, consistent documentation. That is very important. Compile. We've talked about this in numerous videos. We post videos on our website and also on the YouTube channel at Live Free Legal. I would encourage you to go back and watch some of our older episodes that talk about evidence to gather in cases of domestic abuse. But compile text messages, emails, voicemails, social media messages that show a pattern of manipulation, threats, or gaslighting, so that when he says, oh, I never speak to her like this, or I never behave like this, you can show, hey, look, I have this text message or I have this email message from him in January of 2024, and in April of 2024, and in June of 2024, and in August of 2024, and so on and so forth, where he's calling you names, he's disparaging you, he's threatening you. You're showing this consistent pattern of behavior that's happening over and over again. You want to maintain a timeline. We talked about this in our last episode. Maintain a timeline or a journal. You want to be writing things down because you are going to forget. And the more consistent you can tell your story, the more credible you seem. Also, with victims of domestic violence, We tend to repress or suppress what we're going through because when we're in these abusive relationships, we're in survival mode. We don't want to think about what we are living through because it's so horrific. And so we start forgetting things. But the more you begin to write down, the more you journal, the more you're going to remember. The more you remember, the more you're going to remember. And that's going to help you complete those journals and those timelines. And so that's very important. When you use this type of evidence, you are rebutting the lies that she's mentally unstable or she's crazy or there's no evidence because you're producing that evidence. Another way to use that evidence is to show that you're being a good parent, you're being a good steward. So don't just bring in negative evidence, right? Showing him being very abusive or negative. Bring in evidence that makes you look good. Bring in evidence to show you are providing updates. You are providing pictures. You are being kind to him. A consistent pattern of communication or messages or evidence to show that the court can trust you, that you are credible, that you are good with your children, and show again that pattern of behavior with you acting as that calm and credible parent. So stay calm and credible and consistent in your testimony. We talk about this over and over again. I don't know how many thousands of cases that I've tried that I tell my clients, just tell your story. That is the most important thing in winning a case. We don't want to go down the crazy rabbit hole that an abuser wants us to go down, and we don't want to get caught up in their lies. Abusers thrive on chaos and often bait victims into appearing unstable and emotional in court. And if they're already making those accusations that you're mentally unstable or you're crazy, then a composed victim undercuts claims of instability or aggression. So how do you do that? You want to practice your testimony with an attorney, an advocate, a friend, a coach, a family member to avoid emotional triggers. So when you're practicing, if you start to experience some of those triggers, you can practice some coping mechanisms or how am I going to handle this when I go to court? The more prepared you are, the better you are going to come across. You do not want to be rehearsed, though. You do not want to appear rehearsed. You want to be genuine, and you want to adequately tell your story. You want to use clear, non-inflammatory language. Let the facts speak for themselves. Again, as we keep saying over and over again, we don't want to call him an abuser. We don't want to call him a narcissist. We don't want to call him names. We just want to talk about what has happened. Again, anticipate the abuser's accusations and prepare factual, non-defensive responses. One of the things that I teach my victim clients to do, especially if they're having a very hard time testifying or remembering their story, and they're having a really hard time processing their trauma, is we develop a theme. And then we stick with that theme over and over again. So if you're being cross-examined or you're being asked difficult questions and you don't know how to respond, go back to that theme. Okay, so maybe the theme is, I have very serious safety concerns for my children because, and then we're going to have maybe 3 things that the defendant has done. And so it might be 1, he's interfered with a therapeutic process by unilaterally terminating my child from therapy, by unilaterally terminating our child from therapy. He has interfered with the medical process by going into the doctor's office and causing such a scene that the pediatrician terminated services. And he has interfered with our child's ability to receive an appropriate education because he continues to go into the school and cause a scene, which is extremely embarrassing to our child. Focus on some of those behaviors and then how it impacts your child. Be mindful, don't say my child, but your child. And then focus on education, medical, therapeutic, dental, whatever it might be that he's doing to interfere, and then just keep repeating that over and over again. I have concerns for neglect, or I have concerns that he's not acting in the best interest of our child because he's interfering with school, pediatric care, educational, those kind of things, and just repeat it over and over again. For example, I had a case recently with a child who was having a lot of issues with eating, sleeping, GI distress, and also with sensory issues. I just had my client default to those 4 things every time she was asked, why do you have so many concerns about dad or the defendant? And she would just repeat over and over again, our child is experiencing significant issues when it comes to eating, sleeping, gastrointestinal issues, as well as sensory issues, and dad is not addressing those concerns, and in fact is delaying him getting treatment. And so we just repeated that over and over again, and that really resonated with the court. So focus on how it's impacting your child and the ways dad is interfering with the child's ability to get to help. So number 3, let the evidence speak louder than you. If you have proof that contradicts a lie, let the document tell the story. I love this on cross-examination. I did this week, I had a defendant who came in and he had his text log. And on that text log, he was telling the court, she blocks me, she refuses to communicate with me. In fact, look at all these messages I sent to her, Your Honor, and she never responded. And guess what we had? We had their actual text messages. And in those text messages, for the same time period, we had all of her responses. So I was able to go up on cross-examination and say, it's your testimony that my client has not responded to one of your text messages in the last month. Isn't that true? Yes, that's true. Here's my exhibit. I was like, oh, isn't that interesting? Let me show you your actual text messages. Does this look familiar to you? When she actually did text you back, and that just paints a picture to the court, shows him a liar, calls him out, and the court's not going to forget that. So bring your evidence with you and say, I'd like to enter Exhibit C into evidence. Here's my text messages that I've been sending to him. He's accusing me of withholding the children, not allowing the children to speak to him, blocking the children. Here's all the messages that show that he's been communicating with the children. Do not argue back and forth with him. Do not get into an arguing match with him in court. Do not get into an arguing match with the judge in court. Do not say he's lying with emotion. Don't call him out and point at him. Don't interrupt. Don't scoff. Make noises. Do stay poised and let your documentation cut through the noise. Number 4, reframe false narratives. If the abuser flips the script and blames you, stick to structure, what happened, how you responded, and your evidence. You do not need to go and defend every one of his little jabs. Focus on protecting yourself and your child. Remember your little notepad with the lies on it. It is important, especially the big lies that he says about you, to go through and rebut those lies. You can say something like, Your Honor, my intention has always been safety and stability. The messages and reports I've submitted show the pattern of behavior I'm concerned about. And then stick to your theme, right? If there's 3 or 4 things he's consistently been doing that harm your child, say, I'm very concerned that my child is really struggling with not eating, not sleeping, having sensory issues that are not being addressed, and having significant gastrointestinal distress, which is not normal for my child. You don't need to raise your voice to show the truth. When you prepare for lies with facts and practice how to say them, you become unshakable. That's how you win credibility, and that's how you protect yourself. Do you want free legal resources like my free lie response planner that you can use before court to get ahead of his games? There is still time to join one of my legal coaching groups starting June 3rd, where you will have exclusive access to legal templates, resources, forms that I will be creating and have available just for you. I created the Empower Her membership and the Live Free group coaching program to walk with you through your legal journey with the legal tools, biblical encouragement, and survivor-centered support you actually need. For just $35 a year, you can join Empower Her, which is a private space filled with devotionals, legal templates, live Q&As, and a supportive faith-based sisterhood. But if you're ready to go deeper, our Live Free coaching groups start June 5th. These are 12-week intensive, topic-based sessions that are trauma-informed and Christ-centered and are designed to help you win in court without losing yourself in the process. They also include customized legal documents after each session that's focused on what we were talking about during that particular week that you will have exclusive access to if you subscribe to one of those coaching groups. You are not alone. You do not have to figure this out by yourself. Let's walk this road together. Join today and let's fight for your future. With faith, click on the link below to join the waitlist and take back your power. You do not have to be a Christian to join. Not ready to get started yet, but would like a copy of our free guide, Top Lies Abusers Tell? Click on the Take Back My Power Now button to start uncovering his lies and living in freedom. I hope you will join us next week, Tuesday at 7 p.m. We have a video cast every Tuesday at 7 p.m. where we will be talking about twisting the word, how abusers use scripture to silence their spouses in court. And we'll have a very special guest, author Rebecca Davis. She is the author of Untwisting Scriptures, and she will join me as we talk about how abusers twist scripture to keep you from advocating for yourself in court. Join us then.